There are four main documents in most estate plans, I would say. So what are those? Hi, I'm Dan Covington. I'm an estate planning attorney. I've been practicing just over 20 years. Most good estate plans, I would say, consist of a trust, durable power of attorney, a pour-over will, and sometimes a living will. A trust, hopefully you're pretty familiar with. It does a lot of things. Primarily, it provides a mechanism and assets for you during your life and during your capacity. It provides assets during the life of your surviving spouse. It distributes after the life of both of you to your ultimate beneficiaries. And it does all of this without the need of probate. You'll probably hear me talk about that a lot because that's nice. Then the durable power of attorney. This is a document, I always need to remind people that it expires immediately upon death, but this is a document where you authorize someone to act on your behalf during your life for your business and finance and your health care. They cannot act, this person you appoint is called your attorney in fact. Your attorney in fact cannot act against your competent wishes. And that's not to say it has to be an attorney. That's just the term of art used for the person you appoint. They can't act against your competent wishes, but they can act anytime during your life. They can act during your absence or your presence. They can act during your incapacity. Again, they just, you're in charge, so they can't act against your competent wishes. Very importantly, in the event you can't really help yourself at some point or anymore, this allows your family to help you and to act on your behalf and to avoid needing to go to court to get appointed as a guardian to take care of your person and a conservator to take care of your assets and your finances. Third, there's a document you may not have heard of. It's called a pour-over will. So you're going to say, well, if I have a trust, why do I also have a will? Well, it's just an abbreviated will. A pour-over will is a backup. It's a just-in-case document, and it essentially just says that your genuine estate plan is your trust, so that if you happen to leave significant assets out of your trust, you just fail to get them titled into your trust. When you pass away, some kind of probate could be done to move that significant asset into your trust, so your trust can manage it, administer it, and dictate the ultimate distribution of that asset. Finally, there's something called a living will. This is something a lot of people want, some don't. It's not a mandate or an enforceable contract, but a living will is really a memorialized statement of your intent, and it tells others essentially, you'll want to look at the language close in these, but they mostly say, including your medical attorney in fact, the person that you named in your power of attorney, that you don't wish to be maintained by life support machines in the event you don't really have a prognosis of recovery. Yeah, I'll leave it at that. It's something that can take that decision away from and take that burden away from your family if you know you've made that choice. If you don't, you really don't sign one of those. So again, these are the four main documents in most good estate plans. I would say a trust, a durable power of attorney, a pour-over will, living will. Ask me about these anytime. Again, I'm Dan Covington. I'm an estate planning attorney. I've been practicing just over 20 years, taking care of people doing this. And you can always find me at Estate Plan Kansas.